Right. Well, good morning, everybody. My name is Jerry Roth. I'm the president of the UIA. I'd like to welcome all of you to this seminar on competition law in the COVID-19 context. Thank you all for being here. As you know, I say good morning because I'm here in California, but we have speakers today from Belgium, Austria, Spain, Poland, and as you probably know, UIA is the world's oldest international law association with members all over the world. So thank you for being here. We have been doing a series of webinars, podcasts, and various online activities over the course of this difficult COVID context. And with that, I'm going to turn it over to our moderator today, Pedro Callol from Madrid. And Pedro, the floor is yours, and I wish you all a wonderful webinar. I'm just going to turn off my camera right now.
Thank you very much, Jerry. Have a good day in California. Thank you very much to the UIA, indeed, for facilitating this these webinars and this means of communication in these troubled times. So today, indeed, we have put together a panel of competition law specialists to deal with various topics which we believe are relevant in the current times. I will present them one by one by the order of speaking. Say for myself, I'll leave myself for the end. But starting with Sophie Lawrence, who's us today. She's a competition partner at Bristows, based mostly in London, but also spending some time when travel is permitted in Brussels. She focuses on behavioral issues, including investigations and litigation, with a particular interest in the interplay of IP and competition law. We have Aleksander STAWICKI, who heads the competition law practice at WKB in Warsaw. He's generally recognized as one of the leading Polish competition law specialists and featured in inter alia, Chambers Europe, Legal 500, Who's Who of Lawyers, competition thought leader. And for many years, he served as the president of the UIA Competition Law Commission. That's why we know him very well. He's also an editor of 2 editions of a commentary to the Polish competition law. Coen, also very well known to most of you, is a partner at Simmons & Simmons. He's based in the Brussels office, where he's in charge of the EU competition law practice. He's got over 25 years experience advising and representing clients before EU institutions, national competition authorities, national courts, and the EU courts in Luxembourg. Sophie and we'll be speaking, by the way, on the cooperation issues later. Aleksander on pricing issues, going on unilateral conduct. We are also very pleased to have Daniel ESCODA, a very good friend and in-house lawyer with Telefonica Spain. He currently leads the regulatory and competition unit at Telefonica. As such, as part of his role is to lead the dispute resolution strategy vis-a-vis a number of national agencies, including the CNMC, the Competition and National Regulatory Authority in the Telecom Sector, the Data Protection Authority, all the rest of it, because actually, even though Daniel, whom I have known for many, many years, has been a very well-known competition lawyer locally, he, in more recent times, has also acquired a very prominent role with data protection, whom, as we know, it has is sort of being looked at increasingly in conjunction with competition law. We also have so Daniel will actually tell us some of his recent experience in the area of telecoms in this crisis and how they have handled COVID. Dr. Christian Schneider is a partner at BP Hügel Rechtsanwälte in Vienna, where he heads the public economic law practice and specializes in public economic law, energy, telecoms law, environmental law, procurement law, and European law, in particular, internal market and state aid. And indeed, we have invited Christian today to give us an overview of what happens in the state aid area at the moment. The one that's speaking, I'm Pedro Callol. I currently head the competition law practice at Callol Coca, firm bearing my name, that we started over 6 years ago as a specialist competition, litigation, and technology law firm. We have operated, as I say, in these 6 years and have gained recognition as one of the top firms in our areas of expertise. all the sort of rankings, chambers, legal 500, DCR, WWL, all the rest of it. And I actually will not yet leave you, because my idea will follow that order of interventions. I will, as I say, not leave the floor yet, because I will say a few words about a topic which I think fits very well all this COVID-19 crisis, which is the issue of foreign direct investment screening in Europe, which, as I say, is indeed a very good byproduct of the crisis. I have some few slides. I don't know if they're on the screen. Colette. Yeah, thank you. So basically, I'll just focus on 2 points very briefly. One of them is, I cannot turn the slide. Yeah, thank you. So I just sort of developed 2 ideas very briefly. The one is the sort of the wider context. How have we arrived to this the current situation in terms of foreign direct investment screening? And then I will focus on one topic which where I think share some experience that we had in the last few weeks, I would say, or a couple of months, in the area of foreign direct investment screening in Spain, because in Spain actually this regime has been approved in the month of April. But it already poses a great deal of questions and doubts as to its interpretation. On the wider context, next slide, please. Yeah, thank you. Well, I mean, basically, there is an increasing trend. I would say it's like a tidal wave, where I think most of us for the last maybe 30 years, 20, 30 years, have seen sort of a great deal of liberalization, or a free trade, so to say. Everybody was keen on free trade. Everybody's keen on free interchange. In the worldwide, I would say it's more of a European thing, also over in Europe as well. But already in the last few years, there was a sort of, perhaps we have been able to perceive a reverse of that trend. One very good example, I would say a bit dramatic example of this reverse motion is the one caused by the Alstom Simmons merger that we all know. In the Alstom Simmons merger, where the European Commission has blocked this merger on the basis of a sort of purely competition law merger control analysis. There's been a great deal of debate sparked by some national governments, in particular in that case France and Germany, who were advocating that the European Commission should maybe leave behind a little bit this orthodox European competition policy and tools, to introduce tools of industrial policy. The mentions have been to European industrial policy. We want to create European champions that can compete with the Chinese in this particular case, although also other US or the other competitors in the international arena. But basically, this has been a new sort of shock to introduce these criteria, which are not purely competition law based. I mean, obviously, the foreign direct investment screening is a technique which is in place in many countries, or at least in the US for a long time, has been in CFUs in the case of the US. We have also seen countries in Europe like France, Germany, the UK also have had foreign direct investment screening regimes for some time. Last year as well, we have this EU regulation 2019/452. Introduced by the European Commission, which is a regulation that attempts to coordinate foreign direct investment screening regimes that take place nationally. The regulation acknowledges that this is a national law competence, purely not a European competence, because what is being protected is the national interest, precisely, okay? But in any event, I think that's been an important legislative milestone in this process. In that framework, where we see that there's already a change, and perhaps pointing out to a change of paradigm, the COVID-19 crisis has arrived, in March, maybe in Europe, continental Europe, and the UK, I would say. before February, everybody was more or less oblivious about this entire crisis. So in the month of March, this has arrived like an earthquake, March, April. In particular, in the month of April, we have seen this massive falls, this stock market rout, with the stock markets falling to the levels of the worst of the financial crisis. And then, well, suddenly many countries, and particularly Spain, I'll turn to in a moment, which is my jurisdiction, but we have seen how governments work, and also not only governments, but also companies, which have in turn perhaps pushed governments, have seen how market valuations of key companies in Spain, for instance, think of the Telefonica, Iberdrola, ACS, Ferrovial, so a number of companies which are perceived as very important national players are really left with a market valuation which, you know, any Apple or Google of the world, we just buy them with, you know, very little financial effort. And then, so I think this has prompted, in some instances, in the case of Spain, certainly, a very urgent overhaul of the foreign direct investment regimes. The European Commission as well issued a number of communications and recommendations recommending member states to actually adopt these foreign direct investment screening mechanisms in order to protect, well, at this moment, the most urgent is to protect the sort of health and industry, pharmaceuticals, but also health infrastructures. But in any event, well, obviously, as I say, I think this COVID-19 crisis has really precipitated this massive shift in mentality and actually, you know, triggered major events. Next slide, please. So in the case of Spain, this has been, I think, a very good example at the national level of what I'm saying right now, because Spain hitherto had a foreign investment regime which was very, very liberal. Really, it was free, it was liberalized, the foreign investment, with the exception only of weapons companies or weapon systems related companies, dual use companies as well. But for the rest, it was in principle a liberal system. Everybody could come and buy anything, you know, subject obviously to the other authorizations such as merger control or whatever administrative authorizations might be required in this case. But there was no foreign direct investment screening regime as such. With all the urgency in mid-April, the Spanish government, by means of an urgent royal decree, introduced this regime. You know, obviously, in legal things, usually doing things in a hurry is not very good for achieving quality. I believe that this has been a good example. This has been, as I say, very urgent, probably drafted in a matter of weeks, if not days. And actually, the regulation at the moment actually leaves a lot of loopholes and poses a lot of interpretive doubts. Another thing is that there is not an implementing regulation yet in place, which obviously is something that will come when it comes. Hopefully, will address many of the questions we are having right now. It's expected to come in the fall because, you know, fall is a process, and actually the government is busy as well with other things. But yes, you know, going to the regulation itself, in the sort of few minutes I have left, basically the threshold is triggered. Any acquisition of 10% or more of shareholding in a company already triggers the, well, subject to the following conditions as well. But acquisition of 10% or more of a Spanish company already is enough in terms of the kind of acquisition. Asset acquisitions with the current drafting are not covered, although obviously if somebody tried to acquire, again, Telefonica's basic network, we'll see what would happen. But in principle, the literal drafting does not cover asset deals purely. Next slide, please. So what is, no. Okay, that's me, or prior slide, please. Yeah, thanks. So what is a foreign investor? Well, foreign investors are considered those that are outside of the EU EFTA space, basically. The law, you know, does contain some anti circumvention provisions. So basically, we look at ultimate ownership, ultimate control. So if even if the indeterminate investor is in Europe, you know, obviously, if it can be traced back, control can be traced back to someone outside of the EU, then it is covered. And an important area which we have actually been able to advise on in the last few weeks, although it's not contemplated in the law is that of investment funds and private equity houses. In many cases, in those, the ultimate investor is outside of the EU. But provided that our conclusion at the moment, our position, is that provided the general partner is based in Europe, that should be fine. It would not qualify as foreign investment. So affected sectors, so once we have this kind of transaction, we have to look at affected sectors. This is the list, pretty much cut and paste from the law of industries that are covered by regulation. Critical infrastructures, both physical and virtual, communications, data storage and processing, well, obviously defense, all the rest of it, essential utilities, but fourth bullet point, sectors involving sensitive information, such as personal data, or with capacity to control such information. This is potentially a massive scope of industries covered by this, and obviously we'll be looking for the implemented regulation to understand precisely what is covered, because at the moment pretty much anything is covered. A further tweak of the current Spanish regulation is that even if an acquisition is going to take place in an industry which is not within the list of the prior slide, so let's say you want to buy a cement, or construction, something very, very basic, bricks and mortar company, even that kind of acquisition will be subject to authorization if one of the following conditions is met. So if the investor is a sovereign investor controlled by a foreign government, then that's covered no matter what industry what the acquisition takes place. No matter in what industry the acquisition takes place. And also if the foreign investor, the second one is even more worrying, because if the foreign investor has already invested in the past in sectors affecting security, public order, public health in another EU member state, it will be covered. So that means that if we have, for example, a US private equity house, which has been active in Europe in the last 40 years, and they have acquired something which is within that category, where at the moment this is not so individualized, then it will, in principle, have to go through the procedure. Obviously, looking forward to having this implementing regulation, because now it's too wide, the scope. After 2 weeks after the first law, there was a legal reform already after 2 weeks, because I realized that there were quite a few loopholes. They have introduced a de minimis rule. They have introduced a simplified procedure for small investments below 5 million euro. And then, which I would say in terms of procedure as well, this is something which generally above 5 million euro investment will have to be authorized by the cabinet, by the Council of Ministers, so very high up, in a procedure which will possibly, based on the experience we had from the past from weapons companies acquisitions, it can go up to generally will take 5-6 months to get the permit. Okay. So I think obviously if you can get advice not to do it, it's best, and we're working on that. Just to finalize that, the law requires a condition precedent, pretty much like we have in merger control. You have to get the approval before you close the transaction. Otherwise, the law expressly states there are no civil effects regarding Spain. And the fines for non-compliance can go up to the size, to the price, to the transaction value. And so they can be pretty substantial as well. Obviously, as I say, still with a lot of questions. We have actually been very busy advising on this topic in the last couple of months already, because at the moment this is obviously posing many questions. So I think I'm gonna give the floor now to Sophie, who's going to be talking about horizontal cooperation. Sophie, thank you.
Thank you very much, Pedro. So I'm going to be talking about a more traditional species of competition law than what Pedro has been talking about, but with a bit of a new sort of slant to it. So normally when I'm advising companies, competing companies on cooperating between themselves with their competitors, we're focusing very much on the risks, making sure that the cooperation is, that there's a good basis for it, but that then there's very rigorous assessment of the application of competition law to that cooperation. Competition law obviously generally frowns on anything that reduces competition on the market, or involves exchanges of sensitive information, allocation of customers, control over where different companies make supplies, and so on. But in competition law, as in life, we're in something of a new normal at the moment, and so some things. But first, it's important to emphasise that to the extent there have been changes, they are very limited and specific in scope. So while many of us have, so I was hoping the slides would move. There we go. Oops. While many of us may have stopped wearing business attire on a day-to-day basis, and we can't go and have a haircut, businesses can't just stop complying with competition law in the way that some aspects of normal life have been suspended. Nevertheless, some derogations and special permissions have been put in place to allow companies to adjust and cope with the current situation, and to ensure that consumers, who are obviously the important focus here, get what they need in a way that they need it. So as I say, some specific derogations have been given, even for the most sensitive types of coordination between competing businesses. I haven't got time in this brief sort of summary to go through all of the derogations in detail, but at a high level, we have, I would see two broad groups of changes to competition law as it applies between competitors. There are those which are primarily intended to benefit consumers, so in particular ensuring access to essential goods and services in times of scarcity, or where there's been greater demand for particularly medical products. And so one key early measure in that respect was an announcement by the network of European competition authorities that none of the authorities, including the Commission, would actively intervene against necessary and temporary measures to ensure the supply and fair distribution of scarce products to consumers. That was followed by a Commission more specific publication, a temporary framework for assessing antitrust cooperation issues during the crisis. And national competition authorities have put out similar publications. So, for example, the CMA, which is the one I'm the most familiar with, has published actually a pretty useful document which gives an approach to business cooperation in response to COVID-19. And that states that the aim is to avoid competition law impeding necessary cooperation. And I think one of the interesting things about the CMA document is that it includes some handy tips on how the normal exception criteria under Article 1013 or Chapter 1 of the Competition Act in the UK, how those are interpreted in the current crisis. Now, obviously, each of those documents has some specifics about it, but ultimately the overall thrust is very similar, and they really raise principles that are very familiar from competition law as a whole, albeit in this slightly different context of looking at, well, here's something we wouldn't normally do, but the way you assess how you do it and how you go about it is actually very familiar from normal competition law principles. So in particular, the focuses are on, is there an overall benefit to the consumer, which in this case is kind of a proxy for competition, and is the measure indispensable to achieve the legitimate goal? So in other words, is it the minimum necessary to achieve the aim, which must itself be linked to the pandemic if you're to take advantage of these sort of exceptional criteria? And so, for example, it's generally been said that pricing coordination of any kind is unlikely to be indispensable, because actually the sort of goal of getting goods to market and to deal with the supply issues doesn't require companies to coordinate on price. And the CMA, I think this wasn't the press release, but it was leaked that the CMA had sent a message to UK private schools, which are fee charging schools, about some discussions that had been taking place between them about the levels of discounting that they would offer to parents in view of the fact that their children are being no longer able to go to school and are being taught remotely. Other guidance that's been put out by the various authorities is also quite similar to normal competition law. So recommendations that if information about stocks held by different companies or whatever it might be needs to be shared, it should be shared in a way that's aggregated so individual competitors can't ascertain how much information, specific information about other companies. and to the extent that a trade association is available, that would be a good way to thing to use in order to reduce the risks. So that's the sort of first group of measures. The other group of measures are those which are more sector specific. I'm not going to talk about those in any detail, but to my mind, those focus, although they still have the same goal of benefiting consumers by ensuring that goods can still get to market, they also have a sort of feeling of protection for producers about them, in particular in view of things like the excess in, for example, milk. It's been widely discussed that there's been excess quantities of milk with all of the sort of hospitality industry temporarily closed down. So the EU has put in place protection from the milk industry for live plants of flowers and potatoes. In the UK, there have been exclusions for health services, again, dairy produce, and also the Isle of Wight ferry, which is a particular piece of infrastructure. And I think we've seen transport infrastructure being protected or removed temporarily from the scope of competition law in other European countries. So that was the sort of first overall theme. The second overall theme to note is that companies have become very used to assessing their own agreements and with the help of their lawyers to confirm compliance with competition law. But in some cases now, notification is required to the competition authorities, and that's the case under the UK exclusion orders. Or even if notification is not required, you may be required to keep records and provide them on request as under the Commission temporary framework. So this is all a bit of a blast from the past in competition law terms. Companies until 2003 were much more familiar with this process of notifying and potentially gaining some guidance or some comfort from the European Commission. And no comfort letters, to my knowledge, have been issued since 2003 until the current crisis, when Medicines for Europe has received a comfort letter from the European Commission in relation to the cooperation needed to ensure that there is access to medicines throughout the crisis. The third thing to note is that clearly, while there is a somewhat more permissive approach, in some respects at the moment, it is very much a temporary period derogation, although the time periods for which it applies vary to some extent. Some of the documents are quite open-ended and remain effectively in force until they're withdrawn at the discretion of the authority. That includes the EU temporary framework. Some of them expressly refer to the potential for them to apply during any second wave of the virus. So that's the case with the comfort letter that I referred to. Others are more time limited, such as the sector-specific exclusions, which are fixed at 6 months. Just a couple of final themes. What does all this mean for the future? It's very easy to sort of get dragged into thinking about what can we do now and what do we need to do now. Obviously, we're responding to a crisis. But I think this sort of temporary relaxation does create opportunity for risk in future for companies that take up options that wouldn't normally be available to them. Because clearly they do need to find a way to transition back to full-blooded competition at the right time. And I think it's prudent to take steps now to provide for those risks. So obviously, it's important when putting in place any additional cooperation to ensure that it is fully compliant with the existing rules, so that it's kept to a minimum, it's kept within the scope of the permissions, doesn't go into any non-essential goods and services, for example, where the justification is likely to be much less. And that the measures to prevent direct contacts where these are feasible should also be taken up. In terms of looking to the period after the crisis, the new normal as it will then be, it would be sensible to start the winding down process sort of well in advance, stepping down towards the end of the permitted cooperation. Once the period is at an end, think about some sort of formal notice to both internally to staff and potentially also to customers. Think about what pricing announcements are made at that time. And one of my colleagues, co-panelists, is going to be talking about pricing in a bit more detail shortly. It would be a good time at the end of the crisis for the companies that have used the cooperation facilities to perhaps refresh standard compliance training, remind people about what is normally permitted, and potentially, if there's a real perception of risk, to even audit communications with the particular companies that you've been cooperating with. For longer term collaborations, so for example, think about a vaccine cooperation between competing pharmaceutical companies. That's likely to be an agreement that will remain in place for a much longer period, but it might be necessary to provide for different phases of cooperation. So for example, while maximum pricing might be seen as a good thing, almost undoubtedly will be seen as a good thing, particularly in the short term, you might want to think about regaining some more pricing independence at a later phase once we hope the pandemic is under greater control. And just finally, quick reflection on if there are any longer term implications of all of this. And I do think that I found the kind of renaissance of comfort letters and the provision of guidance very useful as a possible something that could come back a bit into competition law. And I think there's been quite a bit of writing about how obviously we're in a very intense crisis at the moment, but there is a wider crisis in the form of the climate crisis, and competition law has sometimes perhaps fairly, perhaps sometimes a bit unfairly, been regarded as something of an obstacle to allowing acceptable coordination to try and respond to the environmental challenges. And perhaps the opportunity for increased guidance and comfort would be something that would be a longer term benefit that could come out of this pandemic. And in particular, as the Commission is at the moment in the process of reviewing the horizontal guidelines. And I think that is something that is gaining attention at a high policy level.
Sophie, can I?
Yeah, that was, you're about to tell me to stop, Pedro, but that is actually, I just got to the end of what I was trying to say. So thank you.
Thank you very much. With that, we will come back as obviously to after the presentations to a Q&A session. If anyone has any questions, please type them in the chat of this system, and I'll take them to the extent we can. So with that, we turn the word to Aleksander.
Yes, hello. Maybe before I start with my subject, two short comments on the previous presentations. Starting with Sophie, I think there was a really interesting point about the climate crisis and what use we can make of what is happening now in the competition law. I think it's a very important thing, and we should all hope that maybe this will be the right direction to use these tools also for the future, so that we can respond to a much wider, bigger problem, which is the climate crisis. So I think that's a very important and very interesting point. And then shortly commenting on what Pedro was discussing, I also fully agree that this is a very important issue. Our parliament is now discussing foreign direct investment control measures that will be also very harsh and very far-reaching, and they can be adopted as early as in the beginning of July. They will be effective, and they will also apply to transactions that are currently ongoing if they are not closed prior to the entry into force of this new law. So I believe that in general, this will make investing in Europe, if you are not an EU company, extremely complicated, and you will have a whole set of new regulatory requirements in different member states. So this will be for businesses, this might be a really huge issue. So that's certainly a very important subject. What I've been asked to discuss is a more, let's say, detailed aspect of this all, which is pricing and the approach of the competition authorities towards different pricing arrangements. So for those of you who are not competition lawyers, maybe it's good to say in the beginning that, of course, pricing is one of the key elements of competition. And therefore, the competition authorities are generally very hostile against any attempts to fix prices. And this can happen at the horizontal levels, as we say. And so that means basically between competitors. And then what we have is basically a cartel. You cannot, when you're a competitor, fix prices with the other undertakings that are in the same market. But it can also be happening on vertical level, which means on different levels of supply chain. And here again, under the competition law rules that are widely accepted, it is not allowed to set resale prices. So we call it resale price maintenance. You can only, under certain circumstances, recommend prices to your resellers or set maximum prices, but never fix prices or impose minimum prices on your business partners. So that's also very important. And I think it's also fair to say that these restrictions on pricing are generally treated as hardcore violations of competition law, which means that it's almost impossible to justify them, let's say, in normal times. I say almost impossible because we have a case in Poland, a very peculiar one, where the competition authority approved a horizontal cartel, a price-fixing cartel, but this was on a very small scale. People who were operating boats on a river in Poland, they had one pricing list, and I think the authority was struggling very hard to help them out of this problem and not to fine them. But therefore, they managed to create a precedent that was widely discussed around the world, that there was an attempt to justify price fixing between competitors. But that it's more like an anecdote. It's not really that this is allowed. So in principle, this is all a hardcore area, and you have to be very careful when setting prices in a competition context. And then, of course, can I change? Yeah, slides. It went too far because there is a bit of delay. Yeah. Okay. So what happened in the time of the pandemic is, of course, that we had an increased demand and shortages of supply, and that again meant that the natural reaction of some of the businesses for this situation is to raise prices, sometimes very significantly, and that in consequence prompted reactions from competition authorities from around the world to look at what was happening with prices. And they were using various tools. Some of those tools we will be discussing later on. Let's say traditional competition law tools that I will discuss, but also consumer protection laws, different laws of unfair abuse of contractual advantage. No laws at all. I think that in Poland, the competition authorities was investigating certain price increases and also cancellation of contracts between pharmaceutical suppliers and hospitals. And we are all trying to figure out on what legal ground they want to attack this practice, because I could not see a legal ground for that, but still they were investigating this. Some competition authorities were changing the law to deal with this problem. So there were various attempts, but generally this of course attracted a lot of attention by the competition authorities. They do not like when the prices go up. And there was also a number of investigations in different jurisdictions, including Spain, Italy, France, the Netherlands, Norway, and Poland, into this price increases. Then the question is, of course, what is coming out of this exercise? And as I said, I will limit myself only to competition law. And I think the first conclusion is, of course, that the companies cannot abuse or use this situation to take advantage. I mean, this is the statement from the ECN, that generally you cannot really use this situation to increase your prices, especially by cartelizing the market. And I think it's widely understood that if this is happening, the reaction from the competition authorities will be even more harsh than it used to be in the past. So generally, of course, the simple fact that we have now a pandemic does not justify cartels. As Sophie already mentioned, it is, of course, there is some level of understanding that crisis can also have negative aspects on the competition in many different terms. It can mean, for example, that those with the deepest pockets will only survive and the market will be less competitive afterwards. There might be difficulties, there might be severe economic difficulties, shortages of supply, and this all may encourage competitors to collaborate more closely. And this collaboration can have also different goals. You can try to reduce the output, which will be probably a bigger problem, or you can increase the output to meet the increased demand, which is probably a lesser problem from the competition law perspective. And sometimes some forms of this collaboration, as it has been already discussed by Sophie, sometimes they might be even necessary to ensure supply of vital products. So the question then would be, if we narrow our analysis only to those, let's say, crisis cartels, what is the response to that? And I think that in very general terms, you have to be very careful in this type of with this type of corporations. They would be. It's not that they are not prohibited, and that was already discussed, but you need a really good preparation and justification for this type of corporation. They are rather seen as a very rare exception. This has been recently confirmed by the UK Competition Authority, where they were sending signals to public, to schools, that they should note that the crisis in itself does not justify price fixing or exchange of sensitive information between competitors. So the simple fact that you have a problem does not mean that you can behave not in accordance with the competition laws. I've seen some authors suggesting that a more lenient approach might be that the Netherlands has a bit more lenient approach. I'm not sure whether this is true or not. Maybe Koen can later comment on it. But basically, I mean, we've seen that I've seen some writers suggesting that this could be the case, and we've seen in Israel, as far as I understand, that they also allowed for short-term collaborations if they were necessary for the participant to survive. But still, in my opinion, this would not be something that could, I mean, you should still treat this as an exemption and rather not try to fix prices under the umbrella of crisis cartels. That would be still seen as a very serious offense and probably the very, very last resort, if for whatever reason should this be accepted, it would be really an extreme situation. So even in the crisis situation, fixing prices would be probably something that would be meeting a harsh reaction from the competition authorities. We were also discussing the vertical arrangements, and here again, I don't think that, and I haven't found anything that would suggest that the position here is changed, and so that you can fix prices in the vertical chains of supply. What was quite interesting, however, is to see that some of the authorities were encouraging producers to impose maximum prices on their retailers. That was seen as a way to limit price increases. And that, of course, can be done legally, but you still have to be sure that the conditions for this are met, which is not in every case. So that's something to be considered, but you have to make sure that this is legal. And finally, my last comment is that, of course, there were some attempts to intervene from the government level or to set prices at the state level. From what I have seen or read, they were not very successful. So probably that's also a lesson to be learned for the authorities around the world, whether they should try to intervene in such situations. In Belgium, for example, I understand that there was some prohibition of promotional campaigns for supermarkets when people were hoarding shops, but that only resulted in price increases. So that was not really a very successful attempt. And as far as I understand, in Italy, they have decided to regulate prices for face masks. But that basically meant that the face masks were sent to other countries, and Italians had problems to buy them. So again, not a very good example of price interventions by the governments, and probably a lesson to be learned. So just to finalize quickly, I think that still the pricing issues and fixing prices is something that you should definitely not try at home. It's a very, very tricky area, and I think that the authorities will intervene and will screen all these attempts to trying to fix prices, and the crisis will not be any sort of an excuse for that. And also, I mean, I think that the general lesson is that as we have seen, the tools of intervention can be very different. So whatever, I mean, even if you do it on yourself, on your own, and you have good reasons for that, I think it's the general advice for the companies would be always to have the price increases well documented, so they can always explain why that was happening, and also to explain that it was your unilateral decision and not a cartel. So that would be all comments from my side. Thank you very much.
Thank you very much, Aleksander, because that's been exactly 10 minutes by the second. So thank you much for your. I was
practicing a lot. It was a whole day of practicing.
My only comment would be that actually in Spain we have the same situation where the state tried to monopolize all this trade of masks and stuff, and it just has not worked. It really proves that economics actually it does work. So with that, Coen, please.
Many thanks, Pedro. I will build on the presentation that Aleksander just gave, discuss pricing, but then in a unilateral context. Pricing, but also other forms of exclusionary conduct that we have seen in the context of this COVID-19 crisis. The background to this is basically what Aleksander has just been describing, the enormous market impact that Corona crisis had on the markets, on economies. Consumers being unable to buy necessities or being forced to buy them at very high prices, and distortions in the supply chain and basically shortages for some of these products. Now, that is due to a mix of factors. For some products like hand sanitizers, face masks, there has been an enormous increase in demand, which was not foreseeable. Of course, there has also been hoarding, panic buying. In a market economy, shortages lead to price increases. But obviously, what we all have seen is much more than that, and we have seen businesses engaging in exploitative, excessive pricing. And there are indications also of other types of exclusionary conduct, and that may be behind some of the product shortages that we have seen. Now, what are the possible tools to address this? There is, of course, competition law. It's unilateral, and so Aleksander discussed agreements, collusion between companies, horizontal or vertical. I'm focusing on unilateral conduct. And there, under competition law, it's basically Article 102 of the EU treaty, the prohibition on abuse of dominance, where excessive pricing, for instance, clearly has been qualified as an abuse in the past. In some countries, and Belgium is a country where we will have this soon, there is also a prohibition on abuse of economic dependence. And that is also something that could be used in this as a tool to combat excessive prices or other abusive behavior in the COVID-19 context. Next to competition law, there are consumer protection laws, both at domestic and EU level, which address pricing behavior, but also other types of practice, unfair practices, such as misleading advertising. And then finally, there is regulation, and both Pedro and Aleksander already hinted at this. You see countries where price control is imposed by government, and we also see that typically this does not work very well or has side effects that are not helpful for consumers or people in demand of certain products. I will discuss in a couple of minutes how these tools have been applied thus far. But perhaps before doing that, a couple of comments on the pros and cons of each of these tools. First of all, what we have seen is that competition law has not played a major role, and competition law in the sense of Article 102, essentially. And it's not an ideal tool because there are clear limits to this tool. Why is that? Not because of the type of practice, excessive prices, exclusive behavior, conduct as such is abusive. But of course, these rules only apply when there is dominance, or where you have these rules, a situation of economic dependence or independence. And that, of course, only addresses a very select group of suppliers or distributors, and all the others that are not in that position simply cannot be called to order. So that significantly reduces the scope for action for competition authorities. We also know as competition lawyers that competition authorities are not well equipped to intervene swiftly in emergency situations, and that's exactly what we are going through now. Specifically on excessive prices, there have been a couple of cases, but they are very rare. I mean, it's only a handful of cases that at the EU level where that has ever been addressed. And typically they take years. And so that will not be a remedy to significant price increases that we have seen for some products. And that basically brings us to the two other tools, regulation or consumer protection laws. And what we have seen thus far is that basically all of the action, or most of the action that we have seen, is based on these two instruments and mostly on consumer protection laws. And it turns out that competition authorities, or authorities with a dual role, competition law on the one hand and on the other hand consumer protection, are well placed to address this and to intervene. And I will illustrate that with a couple of examples. At the EU level, unfortunately, there is not a lot to report on because the European Commission is not dual in the sense that I just described. The DG Comp has only powers in the context of traditional competition law. And basically, the only thing that we have seen so far are statements from the Commissioner warning against virus profiteering, announcements that the Commission is looking into excessive prices in the pharma sector, also hinting that they are looking into exclusionary conduct, but we have not seen much more of that actually. There is some work in other departments of the Commission on consumer protection. So there is this network similar to the ECN Consumer Protection Cooperation Network, where there is some monitoring on websites, online platforms, to look out for misleading advertising, false claims in the context of promotion of products that may or that are alleged to combat COVID-19. And many examples have been identified, but that's not, the European Commission does not have enforcement powers in that area. So turning to a couple of member states, and just by way of illustration, others have already been named, but just a couple of examples. Italy is a case in point where the Italian Competition Authority has this dual role. They have enforcement powers based on competition law, but also on the basis of unfair market practices, consumer protection. And they have looked into this quite intensively. So they very early on, they launched, they sent requests for information, essentially focusing on online platforms. They also announced that they opened an investigation against Amazon, eBay. All of that always only on the basis of consumer protection, so not traditional competition law. And there is an interesting precedent. It relates to the wish.com platform, which is a commitments decision. So there was an investigation, and the authority eventually decided to close the file based on commitments, and the commitments related to measures by the platform provider, wish.com, to eliminate misleading advertising, to avoid excessive pricing, and on that basis the case has been closed. So that's certainly a very interesting precedent. France has gone in the direction of price control legislation, and so there have been we have seen that in other countries as well, and that the government imposes maximum prices for typically the hand sanitizers, the face masks, and so on. So that is a route that has been followed in France. The UK finally is again an interesting case. It's CMA is a competition authority, but they have some powers, but not very strong powers in consumer protection. And they have set up a COVID-19 task force where they have been monitoring and also intervening based on complaints that they received with again a lot of focus on the online platforms, Amazon, eBay, the usual suspects. Now the CMA has very limited powers in terms of competition of consumer protection, and basically they asked the government to get more powers and to change the laws so that they could intervene and be a more stronger enforcer of these rules in the UK. Now that has not yet happened, although the UK Prime Minister has stated that there should be, that clearly there is room for improvement there and for changes in the law, but thus far no changes in legislation. So I want to conclude here, hand back over to Pedro and to the next speakers.
Thank you very much, Koen, again for your extremely efficient just 10 minutes and a few seconds. We turn on with that to Daniel, who's going to tell us about the telecom sector in particular. And you need to turn your microphone.
Yes, now, can you hear me now?
Yes, thank you.
Yeah, thank you, Pedro, for your kind introduction, and thank you to the UIA also for giving me the possibility to share my views on these very interesting topics in such a specific circumstances. For all of us, which we are all practitioners of competition and regulatory law. What I'm trying to provide to you is an in-house perspective of the legal debates we are now facing in the companies. In-house, the companies are also vis-a-vis the competition authorities and the regulatory authorities. Once we can assure you, and then it's clear that all different business cases of the companies and budgets and P&L forecasts may not be accomplished, this is the key issue, that this is the triggering event that when the companies need for assistance, need for legal assistance, and need for support on competition law issues. So first of all, let's fix the facts. So as we've been saying during this webinar, there is a shocking situation. There is a shocking situation with a high degree of uncertainty. That means that there has been a sudden change of the consumption patterns of the demand. That's we are facing at present time the companies in general, and in particular the telecoms company. So there's going to be a different profile of consumption. Now data traffic is rising. Fixed voice traffic is rising also. I mean, all the decision-making processes of the consumer has been affected. So, for instance, I would say, how many managers of Uber or Airbnb had come to the conclusion before the COVID crisis that health, I'm not talking about finding an apartment neat and clean and tidy. I mean, I'm talking about health. Had realized that one specific parameter, or the main parameter, so as to make a decision from the point of view of the client to decide who's going to be the provider of the service was going to be health. I mean, it's something completely new. It's something that I would say that there's a new era. I mean, there is a new competitive trend, a new competitive key driver in the market, which is health. Like recently, privacy. Privacy is a new competition key driver, like price or quality. So we've been facing that new services are dawning. The sector of e-health or temperature screening, it's now becoming very lively, and there are also other segments that are beginning to. So what is the situation that leads at? So it's a situation that from the point of view of competition law, it's important to bear in mind this is a situation that could not be foreseen on the business cases, on the budget when the companies were preparing or were trying to forecast the coming years when preparing everything. So that this is an important issue. So what happened specifically in Spain? There has been a general interruption of the administrative deadlines. In Spain, the government decided at the very first stage of the confinement that administrative proceedings that were not relevant should interrupt its deadline. And that led afterwards, after 10, 20 years after, the CMC, the National Competition Authority, issued a resolution stating that all proceedings in which protection of the public or general interest or the basic functioning of the services were at stake must continue. So we've seen that competition authorities, regulatory authorities, they have considered that their duty on market monitoring and market surveillance belongs to the scope of the protection of public or the general interest. That means that in our case, of course, regulation of the markets and also the competition law is fully applicable to this situation of the crisis, of the COVID crisis situation. So the way to prioritize the cases nowadays is connectivity. Everything that stands for connectivity and health and market surveillance are the type of administrative proceedings that is going to be conducted by the competition authority. Let's come to the last fourth fact, which is the third fact, which is the reaction of the public administration. As we've seen before, well, when economic welfare is in danger, the state or the government acts. How has been acting till now? Basically by three different means. First of all, with public statements and press releases stating clearly that competition law is even applicable to the COVID crisis. That's for sure. That's nothing new for us practitioners of competition law. They have open investigations, mainly in the financial sector and also on the health sector and on the sanitary sector, in order to check out if the pricing strategies of the company were not exploitative. Sorry. And the third way of intervening in the market has been with the way that it can is to intervene by fixing prices and regulate the marketing environment for the companies, specifically for the telecom sector. That means that they have decided at the very first beginning of the period of confinement that there is at present time in Spain a ban on price increases, a ban on service disconnections in case of unpayment of the client, and it is a ban of number portability. That means, of course, as has been said before, that creates a side effects. Why? Because what happens if the price which has been fixed by the administration is below cost, that leads to scarcity. That's clear. What happens if there is some general provision of price increases, as it happened in the telecoms sector? The companies, we don't have much more incentive to invest or improve our quality because we don't have back the investment by means of the price. And what happens if there is a ban on number portability on the possibilities to disconnect the services of the clients? That it's clear that there's inefficient allocation of resources. So all of that obviously leads to a question: is to what extent also the administration has to have a joint responsibility close also to the market forces to this crisis situation? Is something just to bear in mind. And what have we done, the companies? What has been the reaction of the companies? We need to adapt ourselves in order to minimize this harmful economic situation. And on the set of activities conducted by the companies, there is something which has been common by all the telecom sector in Spain, is to promote price reduction initiatives. So it is clear that these are pro-competitive initiatives. I'm talking about price reductions, discounts, promotion, new flat rates that have been launched into the market, or enhanced quality of services. For example, providing free access on a very interesting conditions to audiovisual contents in order to counterbalance the interruption of the sport events that we are all suffering. So the companies, we have reacted.
Can I ask you to wrap up, please?
Yes, sure. So that has led us to something critical, which is the real debate. So which is must be our demand to the public authorities, to our demand as a competition lawyers. So we need to ask for the competition authorities to keep calm and study, because it's time to apply competition law regulation on an extremely sensible way. It's time to take into account the real market circumstances. It's time to look for real economic efficiencies of the conduct. It's time to refine the standard of proof in order to support duly all the evidence. So when we're talking about price reduction, we're talking about which is the optimal as efficient competitor test in order to be conducted. So basically, this is the idea I wanted to share with you, in order to consider and to share with you the idea that it's time to sensible analysis. Okay, thank you very much.
That's great. Thank you very much, Daniel, for the very strong statement. Without more, Kwiecinski, please, last but not least, want to give us some info on state aid. Thank you.
So, hello to all. Thank you for the invitation to me that I may speak to you this evening. And well, my topic is state aid implications. What are the state aid implications of COVID-19? Well, can do the slide down. Okay, I will have to do it. Okay. Well, what are the state aid implications? They arise from the fact that in order to save undertakings from bankruptcy and in order to reboot the economy, EU member states have to inject a lot of money into the economy. And those injections of money normally constitute state aid within the meaning of Article 107, Para 1 of the Treaty on the Functioning of the EU. There's only one significant exemption, that is the concept of general economic measure, which means measures not limited to particular undertakings or particular industries. One prominent example for that would be short-time allowance scheme, subsidizing short-time work, which do not distinguish between different undertakings and economies. Well, what are the main legal basis for state aid? As you know, state aid is only permissible if authorized by the European Commission, and there are two paragraphs in Article 107 TFEU, Article 107 paragraph 2 and paragraph 3. Under paragraph 2, the aids mentioned therein, they are compatible with the treaty, which means the European Commission doesn't have any discretion when authorizing such aid, whilst paragraph 3, the aids enumerated therein, the European Commission has discretion whether it approves such aid. Well, and Article 107, paragraph 3, namely subparagraph B, is actually the main legal basis for approving aid in the context of COVID-19. There are only a few cases, maybe 10 out of 161 to 181, I'm not so good with figures, decided so far by the European Commission in such. Those 10 cases, mainly dealing with aid schemes from Scandinavian countries, the European Commission has approved them under Article 107, paragraph 2b, aid to make good the damage caused by natural disasters or exceptional occurrences. That were cases where, for example, large entertainment and event companies had to cancel events, and well, they were compensated for their loss in turnover. Under Article 107, paragraph 3, subparagraph 2 plays the most prominent role, that is aid to remedy a serious disturbance in the economy of a member state. And dealing with that provision, the European Commission has communicated a temporary framework, like in the context of abuse of dominant position. And that framework, that temporary framework, is actually the main legal basis for authorizing aid in the context of COVID-19. As I mentioned, it's a temporary framework and it's not a block exemption, which means that member states have to notify aid, individual aid and aid schemes in the context of COVID-19. But the European Commission is normally, it is very fast in granting approval. There are cases where 8 member states want to grant have been approved by the Commission within 2 or 3 days. So, well, what is the main content of that temporary framework? First of all, that temporary framework has been adopted and published very early at the very beginning of the COVID-19 crisis, middle of March, 19th March 2020, and it has been adjusted and amended 3 times so far. There are 2 basic principles which apply to almost all aid permissible under that temporary framework. First of all, no aid may be granted in favor of firms in difficulties, meaning that the firm has had to be in difficulties on 31st of December 2019, and moreover, the temporary framework in general is only applicable to aid granted until end of 2020, also 31st of December. Well, what are actually the main aid instruments permissible under that temporary framework? First of all, liquidity aid up to 800,000 euro per undertaking. That liquidity aid may be granted in any form whatsoever. That may be a direct grant, that may be a credit, that may be a tax credit, a credit on social insurance. Well, it's not limited to any form of aid. There's only that 800,000 euro ceiling, and the particular ceiling applies to undertakings active in the agricultural sector. Then further aid instrument is guarantees on loans and subsidized interest rates on loans. Well, there the temporary framework provides for minimum guarantee premiums and minimum interest rates. Member states have to impose if they grant such type of aid, and that's rather flexible. The amount of premium and the interest rate depend on the maturity of the loan, and there is a distinction between small and medium enterprises and other enterprises. And furthermore, also ceilings exist, which means that the guarantee on the loan, or the loan which is subsidized by a subsidized interest rate, may not exceed the double wage bill or 25% of the 2019 turnover, or it has to be limited to the liquidity needs of the enterprise for 12 months or 18 months in case of a small and medium enterprise. Then, not that interesting in my view, also short-time export credit insurance may be used as an aid instrument, because after COVID-19 it appears to be very difficult for undertakings to get such insurance on the free market. And then that was amended by the first amendment. There's a set of 8 member states may grant in connection with the development of COVID-19 related products, which means medicines, medical products, protective equipment, face mask, all those things. First of all, 8 may be granted for COVID-19 relevant research and development. That mainly applies to medicines. There we have a ceiling of 100% aid intensity if that aid is not very market near. Then investment aid for testing and upscaling infrastructure. Well, that is aid testing infrastructure for medicines. Upscaling infrastructure is to increase the capacity for medicines. And then also investment aid for the production of COVID-19 relevant products.
Yeah, sorry. Can I ask you to wrap up now, because we are already running out of time, really.
Okay. So, but first of all, I have to jump back. So what did I wrong? So, okay. So further aid instruments, deferral of tax and social security contributions until end of 2022, then wage subsidies up to 80%, and then most important, because it's very new and there's a strong discussion in connection with airlines, recapitalization measures in favor of undertaking, which means state participation in undertakings, both in form of equity instruments and hybrid capital instruments. And there are some limitations, such as remuneration has to be granted to the state if he engages in the companies, and there must also be an exit scenario, and there are also some governance requirements. So I think I will limit to what I said so far, and there's a further slide, but that I would like to leave for a possible discussion. Thank you.
Thank you very much. Thank you very much, Christian. Thank you very much. I have actually one question on the screen, which I think is mostly for you. It refers to the Lufthansa
Yes.
aid package. The question really is more a comment. It says something like, easy to stay in the market with taxpayers' money. So we get into a new monopoly. I mean, I believe you can comment on that. I think I have read today that Lufthansa is refusing the area. You can comment on that. Yeah. And
Yes.
there's no specific
problem is that, yeah. Well, the problem is actually that the European Commission, going beyond what it laid down in the temporary framework, wants Lufthansa to reduce its landing rights and Lufthansa actually thinks that by a cost-saving program, it would have a better position on the market than if the German state engages as an investor and grants a loan. But it's, in my view, it's also a big surprise, because those compensatory measures are not laid down in the temporary framework. And maybe the reason for that is that Air France and KLM, they also get money from France and the Netherlands, but only in form of loans. And the main objective of the European Commission appears to be to prevent a distortion of competition, because if you have an investor, if you have a state as an investor, you can do more with the money than if you only get a loan. That's my opinion on that.
Great, thank you, Christian. I have another question here, which I don't think is more of well, I am not sure this is pure competition, the question says, but some airlines chose to openly violate EU Regulation 261 and deny compensation to passengers on cancelled flights. They are forcing consumers into vouchers with no choice. Any tools to address this? I don't know if anyone can address this question. I can't, honestly. Anyone on the panel? Yeah, it's pretty specific.
Well, I'm affected by that. I think there's a passenger right regulation, and according to that regulation, airlines, if they cancel flight, either have to rebook you or offer you compensation, but that's also a problem of liquidity. So to my knowledge, some EU member states, such as Belgium, I guess, they suspended that passenger rights to get compensation, and in my view, that's a clear breach of EU law.
Great, thank you, Christian. There are no more questions from the audience at this stage. I have maybe one question for Koen, because when I was listening to your presentation, Koen, you mentioned that you know, fair sort of consumer protection is being used. I don't know if I maybe misunderstood at some point in connection with excessive pricing as well. I mean, I'm not an expert in the. I'd like to understand this, how consumer protection can actually meddle into price levels. Can you maybe say something about that?
Yes, that's my understanding also, that in these instances where national authorities have intervened, so public enforcement of consumer protection laws, that they see, so you have rules on unfair pricing, which is an unfair market practice, that excessive pricing is a form of unfair pricing, and it's is on that ground that they have attacked suppliers. So under this broad umbrella of unfair pricing,
I view it as well more as unfair trade more than consumer protection law. Okay, yeah.
Yes, correct. Yeah, correct. Yeah, yeah.
I misunderstood. Well, thank you very much.
In some instances, these were consumer products also, like the hand gels and so on. So that it has been applied in that context as well. Yeah. Mm-hmm.
Yeah, fantastic. Thank you very much. Well, I think we are reaching already almost 4 minutes to 8 in the evening. I don't know if any one of the panelists would like to post any question. Otherwise, I get no more. If nobody wants to post any questions, I get no more questions from the audience. So I'd like once more to thank the audience for your attention, everyone. Thank you very much again to Sophie, Lawrence, Aleksander, STAWICKI, Coen, PLATTEAU, Daniel ESCODA, Christian SCHNEIDER for being here and making this panel, which I think has been very interesting. And I look forward to being in touch with all of you very soon, time permitting and circumstances permitting, hopefully.
Thank you very much.
Okay, thank you very much.
Bye.
Bye now. Bye.
Everybody.
Bye.
Bye.
Bye.